My name is Ken Novenstern from Fredman Baken Novenstern, LLP, and I'd like to wish a Happy New Year to those of you who celebrate the Jewish New Year this September 2022. And the video I'm going to do now is in regard to a part of a separation agreement, the college education piece, that tends to be one of the last pieces negotiated as part of the settlement of a separation or a divorce. And sometimes it becomes a little bit of the um, lost provision in that everything else is so hard to negotiate and so hard to get done that when you get close to the end of the list of issues like college, sometimes it's not given the amount of attention that it requires. I have two cases right now where the provisions in the agreements that were negotiated by other attorneys, of course, are not as clear as they should be concerning things like the use of 529 accounts for the children and also the room and board credit against child support. With regard to 529 accounts, it's very important to make sure that you're specific concerning what will happen with the accounts, when they will be used, first, last, by agreement, and also to make sure that accounts that existed during the marriage definitely get applied toward the children's college. It's important to be aware of Education Law Section 695, which talks about the fact that even though a child's name may be on a 529 account, that doesn't mean that the account absolutely has to be used for that child. The account is actually controlled by the title owner, and unless you have something specific in the agreement, the title owner might be able to do as he or she pleases with that account. So you need to be careful about that. Next, 529 accounts that are maintained by third parties. Grandparents. A grandparent is not bound by your agreement. So you cannot assume that an account maintained by a grandparent is going to be used the way you might anticipate, for instance, for the child named on the account. Again, the grandparent has discretion and does not have to use it for the child named on the account. So don't assume that they would have to use it that way. And finally, with regard to room and board credit, the two matters that I'm dealing with are not as clear as they could be concerning room and board credits. And specifically, the issue that is often not clarified involves whether the room and board credit will be so large to the parent paying child support that it might overstep or obliterate child support for more than that one child. And we have a case right now where that is the exact problem, that the child support for the second child or the third child is getting absorbed by the room and board credit. And there is case law that specifically says that even if your agreement doesn't limit the room and board credit to child support for one child, public policy can override that. And the public policy being that the room and board credit should not impact the other children, that they should be supported as intended and not lose support because of a room and board credit for the first child. So it's just another lesson about being very careful and not getting worn down in negotiating the terms of your agreement. And so please feel free to contact me if you have any questions, and I look forward to speaking with you.